Welcome back. So what about Article 14 of the Swiss Code of Private International Law? What does it mean? How does it deal with the issue of renvoi? Article 14 states that if the applicable law refers back to Swiss law or onwards to another foreign law, that reference shall be observed only if this code so provides. So as you can see, as a general rule, such a reference, such a remission or transmission is not observed. As a general rule, there is no renvoi. This shows you that the Swiss Code of Private International Law is generally hostile to renvoi. But what does that mean in practice? Well, let's have another look at my whiteboard. We have the same starting point as before, except that X is not based in country A, but in Switzerland, which means that for the question of the applicable law, we have to refer to the Swiss Code of Private International Law, assuming that Switzerland is the forum state. And in case the Swiss Code of Private International Law declares the law of country B as the applicable law, we have this situation, the same starting point as in the previous example, in the previous podcast. And again, we assume that the private international law of country B contains a reference back to the law of the forum state, to Swiss law in this case. But in the Swiss Code of Private International Law, we have Article 14, Paragraph 1. And this article provides that this reference back is not observed as a general rule. So there is no renvoi as a general rule, which means that the reference to the law of B is to be understood as referring only to B's substantive law and not to B's private international law. And the end result of the whole thing is that B's substantive law applies to the case. Having in mind the three possible approaches national private international law systems can take towards the problem of renvoi, we can say that luckily the Swiss Code of Private International Law dismisses option 1, which would have been disastrous. And in fact, the solution that is provided for in Article 14 of the Code corresponds to the approach number 3, which is to disregard the renvoi, meaning that the reference to foreign law is understood as referring to substantive law only, at the exclusion of private international law rules. However, there are also some exceptions, but those are very limited. In fact, only 3 exceptions exist: Article 35, Article 91, and Paragraph 2 of Article 14. Let's focus on that last exception. Paragraph 2 of Article 14 states that in matters of civil status, the reference back to Swiss law by a foreign law must be observed. So what does that mean in practice? So here we have again a similar starting point, except that the dispute refers to civil status. So the question of whether a person is single or married or divorced. And for those questions, Article 14, Paragraph 2 provides that the renvoi has to be taken into account in the sense that in the end, Swiss substantive law applies in those cases. Against the background of the three possible approaches towards the problem of renvoi, we can see that this in fact corresponds to the approach number 2, which is to accept the renvoi in the sense that the substantive law of the forum state applies.